Federation versus Freedom by Babasaheb Ambedkar. 5. 2. C. In the matter of administration. When you begin to examine the Constitution from the point of view of administration, you will find certain sections in the Act which lay down rules for the guidance of the federal government, of the provincial governments, and of the state governments. The purpose of the sections is to tell them how they should exercise the executive authority belonging to them respectively. These sections are 122, 126, and 128. Section 122 is addressed to the federal government. It reads as follows: 122.1. The executive authority of every province and federated state shall be so exercised as to secure respect for the laws of the federal legislature which apply in that province or state. 2. The reference in subsection 7 of this section to laws of the federal legislature shall, in relation to any province, include a reference to any existing Indian law applying in that province. 3. Without prejudice to any of the other provisions on this part of this Act, in the exercise of the executive authority of the Federation in any province or federated state, regard shall be had to the interests of that province or state. Section 126 is addressed to the provincial governments. It provides that 1. The executive authority of every province shall be so exercised as not to impede or prejudice the exercise of the executive authority of the Federation, and the executive authority of the Federation shall extend to the giving of such directions to a province as may appear to the federal government to be necessary for that purpose. Section 128 is addressed to the states. It runs as follows: 128.7. The executive authority of every federated state shall be so exercised as not to impede or prejudice the exercise of the executive authority of the federation so far as it is exercisable in the state by virtue of the law of the federal legislature, which while applies therein. 2. If it appears to the Governor General that the ruler of any federated state has in any way failed to fulfill his obligations under the preceding subsection, the Governor General, acting in his discretion, may, after considering any representations made to him by the ruler, issue such directions to the ruler as he thinks fit, provided that if any question arises under this section as to whether the executive authority of the Federation is exercisable in a state with respect to which it is exercisable, the question may, at any instance, either of the Federation or the ruler be referred to the Federal Court for determination by that court in the exercise of its original jurisdiction under this Act. All these sections would have been very useful if there was any possibility of conflict in the exercise of their executive authority by these agencies. But these will be quite unnecessary because there would be, as a matter of fact, no conflict of executive authority which can arise only when such executive authority is followed by administrative act. When administration is divorced from executive authority, there is no possibility of conflict, and the admonitions contained in such sections are quite unnecessary. Now, it is possible that in the federal constitution, the federal government may be altogether denuded of its powers of administration and may be made just as a frame without any spring of action in it. The Constitution provides that the Governor General of the federal legislature may provide that the administration of a certain law passed by it, instead of being carried on by the federal executive, might be entrusted to units, that is, to the provincial governments and the Indian states. This is clear from the terms of section 124. 124.1. Notwithstanding anything in this Act, the Governor General may, with the consent of the government of a province or a ruler of a federated state, entrust either conditionally to the government or ruler or to their respective officers functions in relation to any matter to which the executive authority of the federation extends. 2. An act of the federal legislature may, notwithstanding that it relates to a matter with respect to which a provincial legislature has no power to make laws, confer powers and impose duties upon a province or officers and authorities thereof. 3. An act of the federal legislature which extends to a federated state may confer powers and impose duties upon the states or officers and authorities thereof to be designated for the purpose by the ruler. 4. where by virtue of this section powers and duties have been conferred or imposed upon a province or a federated state or officers or authorities thereof, there shall be paid by the federation to the province or state such sum as may be agreed, or in default of agreement, as may be determined by an arbitrator appointed by the Chief Justice of India, in respect of any extra cost of the administration incurred by the province or state in connection with the exercise of those powers and duties. It is quite possible for states and provinces to combine to rob the federation of all administrative powers and make it only a law-making body. A more staggering situation, however, is created by Section 125. It is in the following terms. 1. Notwithstanding anything in this Act, agreements may, and if provision has been made in that behalf by the instrument of accession of the state, shall be made between the Governor General and the ruler of a federated state for the exercise by the ruler of his officers of function in relation to which the administration in a state of any law of the federal legislature which applies therein. 2. An agreement made under this section shall contain provisions enabling the Governor General in his discretion to satisfy himself, by inspection or otherwise, that the administration of the law to which this agreement relates is earned out in accordance with the policy of the federal government, and he is not so satisfied, the Governor General, acting in his discretion, may issue such directions to the ruler as he thinks fit. 3. All courts shall take judicial notice of any agreement made under this section. This section means that a state by its instrument of accession may stipulate that the administration of federal laws in this state shall be carried out by the state agency and not by the agency of the federation. And if it does so stipulate, then the federation shall have no administrative power inside the state. The benefit of a law depends upon its administration. A law may turn out to be of no avail because the administration is either insufficient or corrupt or inefficient. To deprive the federal government of its administrative power is really to cripple the federal government. There is no federation in which some units of the federation are permitted to say that the federal government shall have no administrative power in their territory. The Indian Federation is an exception. Not only is there a difference between the provinces and the states in this matter, but they also differ in their liability to supervision and direction by the federal government in the matter of the exercise of their executive authority. That difference will be clear if you compare Section 126 and Section 128. Section 126 enacts that the executive authority of every province shall be exercised as not to impede or prejudice the exercise of the executive authority of the federation, and the executive authority of the federation shall extend to giving of such directions to the province as may appear to the federal government to be necessary for that purpose. Section 128 is a section which enacts a similar rule with respect to a federated state, but there is a significant difference between the two sections. 126 says that the executive authority of the federation extends to the giving of such directions to a province as may appear to the federal government to be necessary for that purpose, while 128 does not give such a power. That means that the federation does not possess the federated state to prevent him and does not possess an inherent executive authority to give a direction to the ruler of a federated state to prevent him from so exercising the executive authority of the state as to impede or prejudice the exercise of the executive authority of the federation. That is one very significant difference. Such authority, instead of being given to the federation, is given to the Governor General, who of course under the law is distinct from the federal government, and it is the Governor General who is empowered to issue such directions to the ruler as he thinks fit. A further distinction is also noticeable. When directions are issued to the governor of a province under Section 126, he is bound to carry them out. But he has no right to question the necessity of the directions, nor can he question the capacity of the Governor General to issue such directions. With regard to the ruler of a state, however, the position is entirely different. He can question such a direction and have the matter adjudicated in the federal court because the proviso to subsection 2 of Section 128 says that if any question arises under this section as to whether the executive authority under this section of the federation is exercisable in a state with respect to any matter or as to the extent to which it is so exercisable, the question may be, and at the instance either of the federation or the ruler, be referred to the federal court for determination by that court. The end.